Right, well, it's now 5:35 according to my timepiece, so I think it's probably about time to start. Welcome to this in-person only event. How wonderful. It's great to see you all here. I gather that some people who originally booked didn't realise it was in-person only and thought it was going to be at least hybrid. Well, they're missing out. It's good to be here. As everybody knows, we're here to discuss artificial intelligence and the law, a big topic, so we're certainly not going to cover it all this evening. And as people will no doubt have gathered, what's particularly prompted this seminar is Simon Chesterman's book, We the Robots, Regulating Artificial Intelligence and Limits of the Law, which is recently out. I regret to say that I can't claim to have read it myself, but I see that it has a good write-up from Jacob, if from nobody else. I'm sure it's been well reviewed elsewhere as well. So he will be our principal speaker this evening, but then to comment on the issues raised by Simon's book and particularly his presentation this evening, we have three other distinguished speakers. Eleonora Rosati, who's professor at Stockholm and very well known to the intellectual property community through her endeavours blogging on IPCAT and editing the Journal of Intellectual Property Law and Practice and writing articles and books, a number of which I have now reviewed. We also have Dr. Guan Tang from QMUL and Jacob Turner from Fountain Court Chambers. So with that brief introduction, Simon, over to you.
Thank you very much. Thank you very much, Lord Justice Arnold. Thank you all for being here, and thank you to Spiros and the team at the British Institute for International and Comparative Law for organising this in-person event. And I think it is the first purely in-person event I've done in 2+ years. I'm based in Singapore, where we are more conservative, let's say, than Britain at the moment in terms of COVID protocols. So we would all be going to prison after an event like this, or at least be fined. But it really is lovely to see people. And the difference in an event like this is both that we'll have a kind of exchange of views in person, but also we can carry on afterwards. And thank you to Spiros and team for preparing some refreshments afterwards. But I was told I must sing before I get my supper. And so this is the singing part. So what I'm going to do is present some of the ideas in the book really as a provocation to conversation, trying to provoke the panelists, but all of you also. Because artificial intelligence and the regulation of it, I think, is of enormous interest, but often there's more heat than light in discussion. I was deeply honoured a year ago to give a talk on for the British Institute for International Comparative Law about an article I'd published in ICLQ on legal personality of artificial intelligence systems. And that's part of the book. I'm not going to be talking about that today, but really I think captured some of what I was trying to do in the larger book, which is to highlight that there are some new things under the sun, but not a lot of them. And there is a tendency when confronting a problem like artificial intelligence for some people to assume nothing like this has ever happened before and nothing like this ever will happen again. So we're going to reinvent every wheel. My own background prior to turning to data protection and artificial intelligence in the last decade or so, I'm a public international lawyer. I used to work at the UN briefly, and there's a maximum for those of you who've sort of worked at the UN or who know it, which is often in the context of the UN, no wheel shall go unreinvented, which is not always the best approach. Okay, so on to this question of how can and should artificial intelligence be regulated? And I like to start some of these discussions with a simple slide. This is both a historic slide. It's from 1956 at Dartmouth College. And so this is the retreat at which the term artificial intelligence is widely regarded to have been coined. And I like to put up the slide for two other reasons apart from historical interest. One is the complete lack of diversity. a bunch of white guys sitting around solving artificial intelligence. And diversity is a challenge for AI systems today. We might talk about bias and some of the problems that AI introduces in terms of the data sets that it draws upon. But the slide's also illuminating because it highlights the often irrational exuberance around artificial intelligence, the mismanagement of expectations. Because these white guys got funding from the Rockefeller Foundation for a retreat on the basis that if they were given money for 2 months at Dartmouth College, they thought they could pretty much solve AI. And a couple of generations later, clearly we're not that far. So that's the early history, if you like, of AI. You can go back further, but I started in 1956, jump forward a decade or 12 years. And for other people, this is an iconic image of artificial intelligence from the 1968 film 2001, A Space Odyssey. The film and Arthur C. Clarke's book released in the same year. And the prospect of an AI system determining that its inner programming, its priorities were more important than the lives of its human crew. And that idea of technology turning against humans is not entirely unusual. We've long had sort of Luddites, neo-Luddites, people fearing technology. But what's unusual about artificial intelligence is some of the starkest warnings have come not from the lunatic fringe, but from people who actually deeply understand the technology. So people like Elon Musk, Bill Gates, Stephen Hawking, highlighting there is a non-trivial prospect of artificial intelligence being extremely dangerous, even potentially posing an existential risk to humanity. So I'm not really focusing on general artificial intelligence. We can talk about that if people are interested. I'm focusing more on narrow artificial intelligence. So not the idea of a super intelligence or an AI consciousness. I'm not so interested in robot rights, although we can talk about that. I'm talking more about narrow artificial intelligence and its near-term impact. So for the next 5, 10 years, what challenges will it pose and what solutions can we offer? So in the book, I try to analyze the problem posed by artificial intelligence and break it into 3 qualities of modern AI systems that do pose some challenges to modern legal systems, although many, but not all of those challenges are soluble. And the first challenge is just that they're fast. This is not unique to AI systems. There are many technologies that operate quickly, but computerized technologies these days does pose challenges for regulation when things that if we were doing on an individual basis could be regulated, when they are mechanized, when they are automated, suddenly become problematic. And so an illustration of this is the flash crash of 2010. So if Evangelos, who's sitting in the front row, and I were engaged in some sort of transaction, buying and selling shares, if we were operating very, very quickly, we might buy and sell things a couple of times a minute, maybe even faster than that. But when there are high frequency trading algorithms involved, in this case, there were trading algorithms that were engaging in tens of thousands of transactions every second, which is how in the space of half an hour, $1 trillion was wiped off the New York Stock Exchange. And then the next 15 minutes, most of it came back. And at the time, and indeed for several years afterwards, no one really knew why. And it was linked with these high frequency trading algorithms. So nothing entirely new there, but it does pose a challenge. How do we regulate things that operate faster than a human can? So that's one type of challenge. A second challenge, and this is more sort of focused on artificial intelligence, is autonomy, autonomous decision-making. Think of the autonomous vehicle. And for many people, they worry about decisions that are being made not by a human, but by some autonomous entity that might pose a risk. And so it's kind of striking that you probably have heard news stories about every single autonomous vehicle accident that had a fatality. And there's been around a dozen of them. There are 1 million people who die every year in traffic accidents, the vast majority of which are caused by human drivers. But there is something, I think, visceral within us that worries about an autonomous system engaging in conduct that could then lead to harm, including possibly fatal harm. Now, legally, this is not actually that problematic. What we're seeing with autonomous vehicles is a shift from what we will ultimately at least see is a shift from the responsibility of the driver to the responsibility of a manufacturer as humans become less involved in the driving activity. There are levels of autonomy that the Society of Automotive Engineers have come up with, levels 1 through 5. Level 1, you're doing everything. Level 2, you have things like cruise control. Level 3, you can take your hands off, but you must be ready to seize the wheel at any moment. Level 4, you can basically play a video game. Level 5, there might not even be a steering wheel in the car. And what's interesting here is that manufacturers have realized that level 3 is the most dangerous because the idea, and indeed most of the crashes have involved people relying on the autonomous system when in theory they are meant to be ready to seize the wheel. And what's striking about human psychology is that most of us, if we're driving and paying attention, we're reasonably competent drivers, the million deaths on the road notwithstanding. But if we let go of the wheel and then are meant to be ready to seize the wheel, none of us are particularly competent after a reasonably short period of time. So autonomy can pose some challenges, but I think most of those are soluble within existing regimes. The third challenge is a bit newer, and this does pose some more systemic challenges, which is opacity, the idea of the black box decision-making. So opacity is also not new to the law. There are all sorts of areas of life in which there are confidential activities, there are complex activities, but AI systems, the kind of machine learning systems that we see now, can be so complex that they can be literally impossible to understand or impossible for the machine to explain in a manner that we can understand. And this poses a challenge because one of the reasons for that complexity is linked with the accuracy of these systems. And so you have a trade-off. If a system is engaged in analyzing billions of variables to the point that it becomes impossible to explain, those billions of variables might be the reason for its accuracy. And if you want it to be more transparent, if you want it to be more explainable, you might have to sacrifice accuracy for transparency. And this is a trade-off. As I argue in the book, transparency is a cost. And sometimes transparency is worth paying for. There are some situations where we really need to understand how a decision is made, but some we do not. And so an example I'll give you is in medical care. There are all sorts of medical procedures where at a molecular level, we don't necessarily understand how a process works. Certain pharmaceuticals, we do randomized control trials, and so long as the statistical outcomes are sufficient, X% good result, small Y% bad result, we're happy to roll these out. Even if we don't understand at a molecular level, we will accept those and allow these treatments. It's even more extreme in psychiatry. There are various psychiatric treatments, including some controversial ones like electroconvulsive therapy, that can be useful, that can achieve good outcomes, even though we don't know why, because we don't understand the brain sufficiently. So we don't need to understand everything about our world. We don't need to understand every process. I flew here on a jet. I don't quite understand all of the laws of aerodynamics, but I'm happy to trust that someone does. In other areas, however, we do need to understand. And the example I'll touch on later is the judge, not just because Lord Justice Arnold is here, but if a judge were to say, I find you guilty because statistically 95% of the time with your circumstances, guilt is the verdict, and 5% is an acceptable error threshold, most of us would have a very visceral reaction that that was somehow unjust, unfair. So those are some of the problems. What are the solutions? What are the solutions to these AI systems? Well, the problem is that for much of the 20th century, we didn't get much further than this guy. And some of you might recognize Isaac Asimov, a great science fiction writer, not a great legislator, but famous for his 3 laws of robotics. And for much of the 20th century, this was about as sophisticated as we got. I won't read them out, but many of you would have read his stories. What people forget about Asimov is that if his laws had worked, his literary career would have been brief. And indeed, even in the very first story in 1942, Runaround, where he introduced the laws, a robot is paralyzed by a contradiction between the second and third laws, resolved only when a human throws himself into harm's way to invoke the first. And so I think there has been an undue emphasis over the years on what the rules should be. And this misunderstands the problem as both too complex and too easy. It misunderstands the problem as being too complex because it suggests that we need an entirely new regime to deal with these new entities. And it suggests that it's too easy because if only we could come up with those new rules, then we'd solve the problem. And this is what we get. We get a proliferation of rules, guidelines, principles, ethical frameworks, really starting especially in the 2016 onwards. And the period 2016 to 2018 saw this proliferation of rules, guidelines, principles. You had Facebook, Microsoft, Google adopting them, the Aslamar principles. You had intergovernmental consortia adopting them. You had individual countries. And why in this period? And it broadly coincided with the revelation about what had been happening on Facebook, with the Cambridge Analytica scandal, and the realization that AI systems, broadly construed, couldn't just engage in identity theft. It might not just give you a weird recommendation of something you might want. It goes even beyond bias and entrenchment of discrimination. But these systems could actually change world history, change elections, including in the most powerful country on the planet. And so it was this realization of the real world consequences of these systems combined with social media and the networked world that led to this belief, okay, we need to regulate. But I think it was a mistake to think that the problem was that we didn't have rules. Rather, the problem is how do we apply existing rules? So if you look at all of those different principles, they end up overlapping substantially. And these are 6 of the basic sort of guideline principles that can end up being part of most of these ethical frameworks. The Pope endorsed one group in 2020. And it's hard to disagree with any of them. So human control, transparency, safety, accountability, non-discrimination, and privacy, all good things. The question I would ask is whether we need new rules. Do we need these things? When we say safety, don't we just mean that product liability should apply? When we say accountability, broadly, the argument should be that we shouldn't be able to do through AI systems things that we can't do ourselves. There's normal civil and criminal law should apply. Non-discrimination, of course, AI systems shouldn't be able to discriminate, but nor should we. And do we need new rules for that? And privacy is another way of saying data protection rules should apply. I do think there is something to human control and transparency. Transparency, as I said, is a cost sometimes worth paying. And if we delegate decision-making to systems that we do not understand, that does pose challenges. In the medical sphere, if doctors are outsourcing decision-making to machines and they don't understand the basis for a recommendation, then this is a problem because most of medical legal regime is premised on doctor-patient relationship and patient autonomy. So if the doctor doesn't understand a system, how can he or she make a recommendation to a patient, and how can the patient accept that with a meaningful consent? So transparency is important, and human control is a way of saying that I think it is important that we have limitations on the development of AI systems that can get beyond our capacity to control or to contain. So rather than asking what the new rules should be, I think it's helpful to take a step back, and broadly what the book is trying to do is help those who would regulate our systems say, well, what are the questions we should ask? And I think you need to start with the question, well, why do we regulate in the first place? Well, we regulate for 2 broad reasons. We regulate to address market failures and in support of social or other policies. We regulate because if we didn't, there would be either unfair or unjust or inefficient allocation of losses, or because we don't like the way the losses fall. The 20th century saw evolutions in the way in which we think about product liability, that we went from a system of caveat emptor to realizing that actually saying buyer beware is somewhat unfair when manufacturers are in a much better position to determine the risks associated with their products. And so most jurisdictions now have put the onus on the manufacturer rather than on the employer, rather than on the consumer, I'm sorry. And it is kind of striking that even today, it is unclear whether a computer program is a product or not for the purposes of product liability. Electricity is a product for historical reasons, but it's not clear whether software is a product. But not all things are just about optimizations. Not all things are about efficiency of outcomes. We sometimes regulate in support of social or other policies. So even if, for example, it were efficient to discriminate on the basis of race or sex or sexuality or gender, most jurisdictions would say, well, that's inappropriate. For example, if we were to engage in sentencing protocols that said, okay, well, because of a personal characteristic, we're going to impose a harsher penalty. Most of us would say, well, that kind of discrimination is inappropriate, even if it were effective. So these are some of the reasons why we regulate. There are also reasons why we might not want to regulate at all. Many jurisdictions, and Singapore is high among them, are wary of constraining innovation or losing a competitive advantage. So 3 years ago now, we had a review of the Singapore Penal Code, and the report literally said, we are not going to use criminal law to regulate artificial intelligence because that runs the risk of driving innovation elsewhere. And so what we saw until really 12 months ago was a pretty clear demarcation between 3 approaches to regulation. So you had the US approach, which is broadly market oriented. The US doesn't even have a federal data regulation, let alone regulation of AI. So the US is very market dominated, and that's one of the reasons why US companies are so important. The Europeans had a much more sort of rights-oriented approach, much as with data protection. And China, until 12 months ago, really had very much a sovereigntist approach. A lot of Chinese regulation was about data localization, ensuring that Chinese companies were operating within China, that China was developing its economy. Its 2017 strategy said we want China to be an AI superpower, and we'll talk about AI regulation maybe in the 2020s. But more recently, China has engaged in very interesting regulation, which I'll touch on at the very end of my presentation. But until recently, you might have been, you can simplistically somewhat say that the US is the market-oriented approach, the Europeans are the rights-oriented approach, and China is sovereignty first. So those are some of the questions why we might regulate. A related question is when. So if you're worried about losing competitive advantage, then you might hold back, but hold back for how long? And this is where a book written 42 years ago by David Cullingridge is, I think, very illuminating, The Social Control of Technology. And what's now known as the Cullingridge Dilemma is this very nice way of presenting the dilemma for the regulator. Because at an early stage of innovation, think back to 2004 when Facebook was when it was still called the Facebook, you could have regulated social media, but you might not have understood exactly the kind of problems that we confront today. And so at an early stage, control is possible, but you don't know enough about the risks to warrant slowing the development of innovation. Jump forward to 2022, the costs of regulation have gone way up. There are all sorts of vested interests. It's extremely hard now to regulate social media. And so the costs have gone way up. So how do you navigate that? And different countries around the world are adopting different speeds. So Europe obviously planted a flag just as I was finishing the book. The AI Act came down and I had to quickly put in some footnote references to it. But other countries, again, like Singapore, have gone slow, and they're looking at it very carefully, again, for fear of driving innovation elsewhere. A term that's sometimes borrowed here is the precautionary principle. This is taken from environmental law. And some of you might know this. This is the idea that when there is a risk, you shouldn't have to wait until scientific consensus exists in order to guard against the risk. The problem is if there's no consensus on what exactly the risk is, it's hard. Even if there is a scientific consensus, and think about the debates over climate change, it's extremely hard to regulate. Another term that sometimes gets used, this is masterly inactivity, which I think is an unfortunate term that was used by a Singaporean politician. The idea being that you would engage in a kind of oversight, but not interfere. And we have in Singapore interesting regulatory sandboxes with the Monetary Authority of Singapore, interesting experimentation. I say it's unfortunate because masterly inactivity dates back to British 19th century policy in Afghanistan, where it was said to be engaged in masterly inactivity. And of course, British adventures in Afghanistan in the 19th century ended in humiliating defeat, which I don't think is the intention with AI, but there we are. So if you do decide to regulate, how should you go about regulating? And here, I hope one of the contributions of the book is to divide up three means of regulation, three sort of purposes of regulation that I think suggest different ways, different tools that we can use to address some of these problems that AI does pose without necessarily throwing the baby out, as it were, with the bathwater. And I think the importance is not to focus on supply, but demand. So not to think, okay, we've got a hammer, so every problem is a nail, and to look for what is the actual problem? What is the problem we are trying to solve for in AI? Because sometimes all we really want to do is manage risks. If you think of autonomous vehicles, I think most of us, if anyone is really enthusiastic, we can talk about trolley problems later. But for the most part, autonomous vehicles, transportation, medical care, we just want it to be safe. I don't think there's a moral dilemma as to whether it's a human or an AI system in the driver's seat. I don't think the fact that human drivers will disappear eventually is a moral problem, but I want transportation to be safe. So there are some areas of life we just want things to be, the risks to be managed, get the benefits, mitigate the harms. There are, however, some red lines that I think do need to be drawn. So rather than that kind of utilitarian calculus that you can engage in with transportation, with medical care, for example, I think there are some red lines, and the red line I would draw is lethal autonomous weapons. Now, occasionally people would say you shouldn't delegate decision-making in a war to a machine because it's the environment is too complex, the variables are too many for the machine to make the correct decision, which I think is a terrible argument against AI. Because if there's one thing AI systems are good at, it's discriminating between different circumstances. Yes, it would be hard at the moment, but that comes with a real benefit over humans, which is that most war crimes take place not because of mistake, but because humans are racist, sexist. They get tired, they get angry. We make bad decisions, things that an AI system can be designed not to suffer from. So why shouldn't we hand over the trigger to AI systems? Well, it's not because they would make worse decisions, but because they would make amoral decisions, not immoral decisions, but amoral decisions, that they would not be grappling with the kind of dilemma that I think every decision to take a life should amount to, and that would not be meaningful to hold them to account afterwards. Now, I've been saying for some years that this would be a red line, and that many other people have campaigned to stop killer robots. I fear that this ship may have sailed because there's evidence that autonomous weapon systems with independent capacity have already been deployed in Libya 2 years ago. There are stories that they might get deployed in Ukraine right now. But at least to me, this is one of these red lines that I think the life and death decisions of another person is one place to draw a red line. And then there are other decisions, what I call process legitimacy, which I think are important for not just any human to make. If you like, this sort of tripart distinction is the managed risks that it doesn't matter whether a human's making it or not. The red lines, it should be a human making the decision. And there are some decisions where it's not just any human, but a particular human. And I've never had this talk with a judge in the chair, and this is not pandering, but the idea behind this is that some decisions are legitimate not because of the brilliance of the human making them, but because of the position he or she holds within a politically accountable hierarchy. And I say politically accountable rather than democratically accountable, because the legitimacy of a judge making a decision comes from his or her role within a legal system. There's a line attributed to Oliver Wendell Holmes that the US Supreme Court, on which he sat, he said, we are final not because we're infallible because we are final, which is to say that the US Supreme Court justices are very good justices, but they're not made final because they make no mistakes, but because you need someone to make a final decision. And the political accountability within that structure is sufficient to justify the legitimacy of those decisions, although we can quibble about what we think of the US Supreme Court. So I'm getting to the end. This is, of course, a book that should have been written in pencil because things change all the time. I mentioned as I was finishing up the text, the EU unveiled the draft AI regulation. And almost immediately, we had consultants saying, all this is going to do is cost the European Union money. In my home country of Australia, there was an interesting step in August last year when an AI system was recognised as an inventor for the purposes of patent law, something that the UK Patent Office, the European and American counterparts had all resisted. But there have been some crusaders like Ryan Abbott trying to establish that an AI system could be an inventor. It did not get any rights, but it was at least recognised as an inventor for the purposes of the patent law. Meanwhile, in my neck of the woods in China, China has been engaged in this really extraordinary effort recently of regulation, to the point where I have a friend who plays a game, which is to translate a bit of Chinese legislation for AI and ask a panel where they think it came from. Because a lot of it, if you didn't know, looks very European, because it's very rights-oriented. It's all about transparency, all these sort of good liberal values that China is at least partially adopting with regard to the private sector, not with regard to the government. And in America, we've now had a resuscitation of the Algorithmic Accountability Act, which might yet go somewhere in Congress. So all of this to say, it's a fast-moving topic. I'm very grateful for the opportunity to share some ideas with you in person, really provocation to conversation, but I'm looking forward to the response to the panel, your questions and comments, and then the opportunity to share a drink afterwards. Thank you all very much for your attention.
So thank you, Simon, for that very stimulating talk. And as I said earlier, we've got a number of panelists who are going to comment before we throw it open for discussion. And first up, we have Jacob.
Thank you very much, Lord Justice Arnold. Thank you to the British Institute and Spiros for the invitation. Thank you all for being here in person. And thank you to Simon for giving us the reason to be here in person, and also for writing a fantastic book, which I can claim to have read. I highly recommend to everyone. I have been asked to give the perspective of a practitioner working in this area and advising governments, regulators, and increasingly private parties on the types of issues that Simon has written and spoken so persuasively about. There are three trends that I would highlight in the last couple of years in global AI regulation and governance. The first is that dangers are increasing for organizations which are using AI. And there are a few illustrations of this. We're increasingly seeing regulators taking a robust approach to such regulations as exist and as have an effect on artificial intelligence. And as Simon has rightly mentioned, a lot of regulations will already apply to the use and deployment of artificial intelligence. We don't need to wait for new laws to see enforcement. Enforcement can already take place under existing laws. A key piece of legislation in this regard is the GDPR. Now, we'll all be very familiar with the data privacy aspects of the GDPR, but what people tend to be less familiar with are the aspects of the GDPR that relate directly to automated decision-making. In particular, Articles 13 to 15, which require meaningful explanation on the logic involved, be provided where there is solely automated decision-making, which is sufficiently important to a person. And secondly, there's a right not to be subject to solely automated decision-making unless you can come under certain exemptions. And we're increasingly seeing regulators becoming more confident about applying these rules to businesses who are using AI. We have seen it in particular in the gig economy. I've been involved in some litigation acting for a group of drivers who were essentially sacked overnight by Uber and Ola cabs. They were accused of having committed fraud. And it was a bit like something out of Kafka. They received a 4-line message saying, fraud has been detected on your account. We're therefore terminating your contract. No questions asked, no right of recourse. These drivers challenged it in the Dutch courts and were partially successful. The Dutch courts ruled that they hadn't been given adequate explanation of how the decision had been reached. And it transpired, as we suspected, that the decision had been informed by algorithmic decision-making. In fact, Uber boasts about this on their website, and they talk about how they're using machine learning to detect fraud. Uber succeeded, however, in their defense that they weren't taking these decisions based solely on automated decision-making, that there were humans in the loop. And I'll return to that at the end, because I think that's a really important point, and it goes to aspects that Simon was talking about in terms of where we draw red lines as to where we say it's fine for the AI to make the decisions and where we say we need to have a human making the ultimate decision. The second trend is that AI is increasingly being treated in the same way as environmental, social, and governance restrictions on what businesses can do. So in the same way that we've seen ESG becoming an increasingly important part of the way that corporates act in the last 5 to 10 years, in circumstances where essentially it was purely voluntary before, it basically didn't exist as something which businesses were required to do. Now it is a very important part of their reporting. We see this in things like modern slavery statements, in annual reports, all of which go to describing what is being done and indeed not done by particular companies in the ESG world. And we're seeing companies trying to comply with best practices around the world by adopting similar sorts of governance techniques with regards to their AI, albeit that we are starting from a pretty much a standing start on this. So it's the case that most companies are not complying with these sorts of disclosure requirements, but some now are, and that is the trend. The final trend that we're seeing is transparency statements being a key part of how companies can demonstrate that their AI is trustworthy. And transparency and explainability is something that Simon discusses at great length in his book and makes a number of interesting observations, one of which is that there are two approaches to explainability and transparency with AI. One approach is a ex ante approach, where you give information on the way in which the system was set up, the data that was used in programming it, the safeguards that have been placed around the system, essentially an algorithmic impact assessment, which is provided in advance. So that's one approach. The other approach is an ex post approach, where for individual decisions made about a person, either automatically or more likely when and only when they ask for these explanations, the explanations are provided to them, and the explanations are detailed and subjective in as much as they're unique to the person who has requested them. Now, the latter, it transpires, is extremely difficult to do, given the nature of AI, which, as Simon mentioned, at least when you're using machine learning and deep learning techniques, is typically opaque. So the move rather has been, and this has been something which is being broadly sanctioned now by regulators, is to provide ex ante statements, so public-facing statements which explain in, say, 10 to 15 pages and in easily understandable terms how and why a company is using AI. So those are the three broad trends which I have seen at the coalface, as it were, in terms of advising both complainants and the defendant organizations on AI governance. I'd like to close with a question for Simon, if I may. It arises from a practical example that I spoke about earlier, the Uber case. Now, as I mentioned, Uber's defense succeeded that they had a human in the loop. They didn't need to provide meaningful explanation about the logic involved because humans were taking the ultimate decision. Now, we're challenging that in the Dutch Court of Appeals, asking what it means to have a human in the loop. If a human is just rubber stamping what the AI does because they are convinced that the AI is better at making these decisions than they are, then is that sufficiently meaningful intervention? And I think that it's fair to say the way that technology is developing, in many circumstances, AI systems are demonstrably better than humans already in things like identifying cancer. And in such circumstances, having a human in the loop would only introduce error rather than reducing it. So my question to Simon is this. You end the book on a fascinating prophecy. You say, to paraphrase, AI systems force us to question the centrality of humans, of human decision-making in our legal systems, but it is not yet time to relinquish that centrality. So my question is, if not now, when? Thank you.
So, Jacob, having posed the question, I'm going to invite Simon to answer it.
Oh, I was going to think about it for a while. Okay. I was going to write down some notes. So, no. Well, firstly, thank you, Jacob. I'll be very brief because I want to hear. I want to leave time for others. I've said enough. But so I think this question of human in the loop is. It's a bit like the problem with data protection. I assume many of you are familiar with data protection, that the get out of jail free card in data protection, the kind of quick and dirty solution to data protection is consent. And so, okay, you have all consent, it's time for audience participation. You have all consented to terms and conditions in the last year, definitely, when you've updated software, you've installed new software. Hands up who reads all the terms and conditions. I publish books on data protection. I don't read them. It's a waste of time to read them. And this is why the GDPR, Singapore more recently, are moving away from this consent model. And that's my fear of the human in the loop, that the human in the loop is precisely the rubber stamp. It's the greenwashing or the money laundering because of this phenomenon of automation bias that Jacob's alluding to, that we tend to put undue weight in AI system. There are all sorts of experiments, and with my other hat on at AI Singapore, we're doing grants, we're offering grants on sort of AI governance and AI trustworthiness. And there's some really interesting experiments that are going on, trying to work out in what circumstances humans will in fact trust AI. And they're not always good circumstances. People will make bad decisions. So this doesn't mean that we should give up our centrality to the legal system. It means we've got to be clear-eyed about how humans make decisions. And maybe the last thing I'll say is that there is a perverse danger that by valorizing human decision-making, we sometimes lose, as you were saying, the best of AI in your radiology example. But there's also the countervailing challenge that sometimes we hold AI to a higher standard than humans. And this is a phenomenon in bias determinations, that an AI system, if you interrogate an AI system and ask if it's biased, it will normally try to tell you the truth. Try asking a human that, Try asking a human, are you sexist? Are you racist? No sane human is going to say yes. Sometimes they will reveal that they are, but there is a risk that by interrogating AI systems to the point that we lose some of the utility, or valorizing humans, that we ignore the fact that humans are often a black box ourselves. So I'm kind of more responding to your question perhaps than answering it, but maybe I'll come back with a better answer in a few minutes.
Right, so next up we have Eleonora.
Thank you very much, Richard. Thanks, Spiros, for the invite. I'm very grateful to have the opportunity to be in this panel this evening. And I will be sharing indeed some of the thoughts that have already been expressed from an IT perspective. And when we speak about AI from an intellectual property perspective, there is something that has been very visible over the past 4 or 5 years, and something that has not been as an immediate relation in connection to IP. The very visible thing is something that also you, Simon, flagged, this question whether AI inventions, AI creations deserve protection. So a lot of focus has been on the output. Can indeed something invented by an AI be patentable? Can something created by AI be protected by copyright? And indeed, the answer so far has tended to be in the negative, with the exception of Australia, insofar as patents are concerned. I don't think that there has been a success anywhere else. For copyright, it seems that things are not brighter at all. And if I start from the United Kingdom, there is a provision in the Copyright Designs and Patents Act, which according to some can be used to protect through copyright, if we want to call it like that, computer generated works. No, I'm not sure that is copyright from a continental perspective. In the UK, there is not an express concept of related rights, etc. But if we look at the CDPA, that provision in section 9 is in fact a related or even a sui generis right. It is different from copyright. It has not been used to protect artificial intelligence creations yet. No one has made a solid attempt in this sense, but according to some, a provision that was introduced in 1988 to protect satellite photographs, among other things, could be used to offer some form of protection to AI creations. In the US recently, there was an additional attempt to obtain registration for a work created by AI. It was from the same group behind the AI patents. And there, the US Copyright Office refused the registration on grounds that human authorship is required for copyright to arise. And it seems that in Europe, the answer would be in the same sense. In fact, if we look at the relevant copyright directives, there are references to human authorship that is found in the software directive. The DSM directive refers to authors and performers as natural persons. And then there are other directives as well. So this emphasis on the output so far is intriguing, but I don't feel that it is the most pressing issue. When we speak about AI from an IP perspective, there are 2 themes that I think are more pressing right now. The first one is whether and to what extent intellectual property rights restrict the development of AI. And here I make an example. If we have an AI that creates a painting in the style of an artist or creates music in the style of the Beatles, how can that be possible if not by giving the AI the Beatles repertoire, that artist corpus? So of course there is the engagement of activities that, among other things, the copyright law does restrict. So there is the question whether intellectual property law, among other things, can restrict machine learning activities, development of AI, etc. And that is one topic. The other one is very closely connected to what was raised in the previous comment, and indeed it is the use of automated technologies for the protection of intellectual property rights. So I will start from the first one, IP rights restricting machine learning, AI projects, and so on. And this is a fact. It is true that there is a copyright as an obstacle to the development of AI. There is the question to what extent copyright should be lifted so that these activities can be allowed. And what we've seen, speaking of regulation over the past 8 years or so, is indeed the introduction of new exceptions to copyright that would allow all these activities without a license. The first country in Europe to actually introduce an exception in this sense has been the United Kingdom in 2014. As far as I know, the new exception remains unapplied as of today. But indeed, there is this possibility to at least engage in copyright restricted act without a license for non-commercial purposes. Then other countries in Europe followed the UK example. There has been a legislation in France, Germany, Estonia, Ireland was preparing to legislate. And then now in the European Union, there are 2 new exceptions to copyright, allowing indeed these types of activities with the idea of making Europe more competitive. But these things are not just happening in Europe. We have examples from other jurisdictions as well. The first country to legislate by introducing an exception to copyright was Japan. Then there has been legislation in Israel, in the United States. There is the question whether the fair use doctrine can uncover these activities, and the answer seems to be in the affirmative due to some guidance from case law. There has been the recent copyright reform in Singapore, introducing indeed a specific text and data mining exception, and so on. So this problem of whether IP restricts AI development is a very real one, and probably it has been the least visible but most relevant one from a regulatory perspective, where something has really happened. The final topic, and then I will conclude, is of course the use of artificial intelligence for the protection of IP rights. And here there is a big topic, at least for countries that are still member states of the European Union, and it is Article 17 of the DSM directive. This is a very controversial provision. I don't know whether you have had the opportunity to read the text of it. It is 10 paragraphs of complexity. It has been described, I think, in the most accurate way as an employment program for IP lawyers, because it is indeed very difficult to make sense of what this provision requires. But in a nutshell, it is premised on the idea that certain types of internet platforms are responsible for the uploads that their users make. Translated, if I upload a video on YouTube, from a copyright perspective, what we have always told our students is that it is you who are performing a copyright restricted act. And the platform is indeed a repository, but in itself does not perform a copyright restricted activity. That is no longer accurate, because with Article 17 being adopted at the European Union level and being transposed in national legislation, it is the platform that also communicates and therefore needs to obtain a license to allow users to perform all these activities. But where does AI come into the picture? It comes into the picture in the event that the platform has not obtained a license. So YouTube may not be in a position to get licenses from everyone. First of all, because there might be situations in which you didn't even think that you might need a license. There might be sectors in which licensing is not really something that has ever been developed. And of course, right holders are not required to give you a license. They might refuse to do so. So how do you escape liability if you are YouTube? There is a complex system of requirements that need to be fulfilled. Among other things, the consensus seems to be that you need to implement automated content recognition technologies, also known in jargon as upload filters, that indeed serve to detect matches with protected content and prevent the upload of this potentially infringing material. And there is the question, of course, you don't do these things manually, because just to put things in perspective, every minute on YouTube, there are 400 hours of content that is being uploaded. So you cannot have people manually reviewing all these uploads. You employ technologies that more often than not rely on artificial intelligence. And here, of course, there is the question, but what if there is content that should go up and it is not allowed? Is that something that we can tolerate as a society? Is that an undue compression of freedom of expression? And the answer is not just academic, it is a very real one, because the Republic of Poland, shortly after this directive was adopted, lodged a complaint with the Court of Justice of the European Union, requesting that Article 17, at least in this part, be declared invalid due to a conflict with freedom of expression as protected by the Charter of Fundamental Rights of the European Union. So this is an action that is still pending. The Court of Justice will decide the fate of this provision next month. So far, the Advocate General appointed in this case has advised the Court of Justice not to invalidate Article 17, but, and here I conclude, this is an example that shows very much how the topics that were raised in connection to the GDPR automated decision making are also very much felt in the IP field. Thank you.
So of Eleonora's 3 points, I'm just going to ask Simon to respond briefly to the first one. And the way I would pose the question is this. You talked in your presentation about regulating risk. But of course, in the IP context, one is not regulating risks, one is regulating incentives. And I wonder how your approach applies to that question.
Thank you. So in some ways, it ties back also to Jacob's point about human centricity. Why are we so concerned about protecting the rights of human created things? I'll focus just on copyright, and not concerned about protecting the quote unquote rights of AI systems. And it partly goes back to incentives. The history of copyright law, Eleonora knows this much better than I, is about incentivizing and rewarding creation. That if anyone could copy someone else's creation, then the incentive to create would either diminish or the rewards associated with creation. So if anyone could just photocopy my book, no one would buy it. And then I'd be, well, actually I wouldn't be unemployed, but because academics don't actually make any money from their books. But so why do we care? Why is it different? And as she highlighted, why is computer-assisted creation in the British, in the Copyright Act here different in that it doesn't, so it's 50 years, but there's no sort of life plus, there's no moral rights associated with computer-assisted creation. And ultimately it comes down to a kind of speciesism, which is where I sort of land up. And this is something I touched on in my lecture last year, that projecting forward, and this is where we do go into science fiction. I mean, AI systems at the moment are very good at creating works. I don't think there's any doubt that the sort of things that Davos is creating could be patentable. The sort of the GPT-3 produced texts could be copyrightable. So why don't we copyright them? And often it comes down to incentives, that humans need the incentive of that protection in order to keep on creating. Otherwise, we'll be lazy and indolent. We won't do the work. Computers don't need that incentive. Computers just need a power source and someone to say run or go. So there is that incentive. But again, projecting forward, why do we protect the rights of humans and not the rights of synthetic entities that might end up being almost indistinguishable from us? And there, I think we do have to fall back on this idea that we are at the center of our legal system because we created it, and we candidly do need to defend it. Because otherwise, if we ever get to the point where AI systems are of equal status to humans, I think this is where, again, we're nudging in the direction of science fiction, that the false perception created by science fiction is that if we ever do go down that path of general artificial intelligence, it'll be like Asimov's robots. It'll be human-shaped, human-level intelligence. Whereas the computer scientists I at least know and trust warn, if we ever get to dog-level intelligence in an AI system, it will very quickly, it won't go dog-level, average human, Albert Einstein. It will very quickly overtake us. And that's where the idea of human control of AI, I think, starts to become important. But short answer to the question, yes, incentives We need incentives to encourage humans to create. We need rewards to ensure that we will create and be valued for our creations. AI systems don't need that, and that's why they don't deserve it.
Right, so our last commentator, but far from least, is Guan.
Thank you, Chair. Thank you, Simon. Thank you, Spiros, and thank you, my colleagues from BIICL. You've done a great job. Noam, thank you so much. I enjoyed very much Simon's talk as much as your book. And it's like you are reading the story. So I understand the roadmap, how you constructed this work. It's a wonderful experience for me. We all know that Tony and I had a very quick chat, how complicated these issues are currently we are facing. But Simon's book, so I recommended you to read it, put it in a very clear and simple, structured way to show you how we can deal with complicated issues with a very simple, focused approach. That's what I like about your book. That's also what I like about your talk. However, I do have a mission. Spiros gave me an assignment to say that you have to really ask Simon the most interesting question to you. And to me, I would want to focus my question on chapter 5, which you mentioned about the possibility of legal person status for AI, but you definitely turned down the thoughts. And based upon my very limited understanding, you gave the reason to say that it's because of the complicated types of AI, and the variety of AI will make it very challenging. And also it tends to be like we put everything under the umbrella of AI. And you also mentioned a key word, which is consciousness. My late father was a historian, and he always told me stories from far, far away and from long, long time ago. So I also take the approach when I research, when I study, when I read Simon's book. I think we should take history as a mirror. So where we are now, we are facing a situation that AI is challenging the current system, but we are hesitated to grant rights and responsibilities, to limit the risk, and put in your words, to put AI more under the control of human beings. Personally, I would think to consider granting AI legal person status would be one of the most efficient way to limit the risk and to put AI under control of human hands. We have history of the development of company legal personhood, and that happened during the 18th century. That's the Industrial Revolution, one of the results from the Industrial Revolution. And where we are now, we are in the so-called fourth Industrial Revolution, and we have AI everywhere and greatly promoting productivities and also challenging the current legal systems. And my colleague panelists mentioned about how to fairly limit the risk in the automation situation and also in the IP protection situation. It would be so simple and straightforward when you have a system of legal personhood in hand, then rights can be so well defined so as liability. So my question would be, Simon, why did you not think this would be something to at least take into consideration, and now is the right moment to think about it?
Well, I thought about it for a chapter and decided, no, bad idea. No, so you raise a really interesting question, and it is a fascinating topic, and indeed we spent some of the time last year in my talk where Liam was not in the room taking photographs. He was organizing everything in the background. So Liam, in person, thank you. Nice to finally meet you. So I think it's absolutely clear that most legal systems could give legal personality to AI, because most legal systems could give legal personality to almost anything. So you mentioned corporations. Legal systems have given legal personality to famously sort of temples in India, a river in New Zealand, the ecosystem of Ecuador. You can give legal personality, but should you? And you highlighted some of the reasons why I think it's a problem. One is the category is vague. So when you say give legal personality to AI, what would that even mean? So as a category, but you could give every autonomous vehicle legal personality. I mean, you could already do that just by constituting it as a corporation, but what value would it have? And to me, the demand is insufficient and the cost would be too high. The demand is insufficient because corporations are given legal personality. It's back to incentives to encourage risk taking and to limit liability, and that serves an economic function. And there's a whole debate about the extent to which corporations can and should be given independent personality, but most jurisdictions allow some kind of corporate activity where humans can do things together, limit their risk, because that promotes innovation, promotes economic activity. Would that be the case in AI? Well, there have been some arguments. So Ryan Calo, a decade ago, said that you need to give developers immunity for AI systems, because otherwise the risks are too high. People will be afraid to innovate. Now, I think he was wrong then. I think he's even wronger now, if that's possible, because it clearly hasn't constrained innovation. But what benefits would it entail? So if there were real liability gaps, that would be one thing that it might assist. If there were autonomous vehicles killing people on the road, oh, no one to sue, then maybe you need to go after the AI system. But you can go after the owner, the operator, or the manufacturer in most situations. Or if we move away from sort of embodied things, eventually what AI will be more likely to be is distributed systems, not necessarily with any kind of physical manifestation. What benefit would it entail? Well, again, if there's no one, if there really is no one you could attribute things to, no traditional legal person, a human or corporate entity, then there might be an argument. And here I kind of show my cards by saying that's what the human control thing is meant to stop. That I think there should always be a human or a corporate entity that you can blame things on when things go wrong, or reward when things go right. And that goes back to the IP point. But your last point is the most interesting one, which is this idea of, well, but you could also have rights. And if, again, we project forward to the idea of, and you mentioned consciousness, of some sort of artificial synthetic entity that has rights and interests and looks a bit like us. And the problem is there's no real prospect of getting anywhere near that in the near future. Far into the future, conceivably, but even the kind of machine learning techniques we were describing earlier, there's no serious suggestion that we're heading towards anything like consciousness. But if we ever did go down that path, then there are two things to think about. One is, yes, I think you're right that most legal systems where they have expanded the notion of personality, they tend to be more just. And so the history of legal personality at the moment, everyone in this room is fully entitled to full legal personality. But a century ago, maybe less than half of us would have been, depending on our gender, race, where we came from. And so most legal systems do sort of expand their notion of justice. And that's helpful in two ways. One, because we can be more just, we can be fairer, we can learn. But also the hope is, and this goes back to the idea of AI surpassing us, and I think this is implicit in what you're saying, the sort of half argument in favor of AI personality that I'm sympathetic to, but I don't think we're there yet, is that if you do think we're going to get overtaken, then bringing AI systems into our notion of justice means there's a slim possibility that when we're overtaken, it will embrace the same kind of notion of justice and the same sort of charity that we offer to it, it will offer to us when it becomes our masters. And so we'll give it more rights than we currently give chimpanzees. But I think that's a fascinating thought experiment, but I don't think we're anywhere remotely near that yet.
Well, that's beautiful, because that leads straight on to the question that I wanted to ask. So Simon gave us the example towards the end of his presentation of the limit on regulating AI of judges. And he posed the question, do we want judges to be replaced by AI systems and to determine cases? And he suggested that the answer to that was no. And he suggested the reason for that was because judges have what he called political accountability, which in a democratic political system, one might call democratic accountability. And don't forget, the fact that judges are not elected under systems such as ours does not mean that they do not have democratic accountability. They do. And we can debate that if people doubt it. However, I wonder if the true answer is not more existential than Simon suggests. And I will explain what I mean by that. It is already the case that lawyers use AI systems to predict the outcome of cases. All you need is sufficient data on decided cases, and you can build an AI system that will then predict the next one. And in certain areas where there's plenty of data, these systems are highly accurate in terms of predicting the outcomes of what we might call simple legal cases. And indeed, the technology is rapidly advancing so that you can predict even more complex legal cases. Now, if your AI system can predict the outcome with a high degree of statistical confidence, you might say, well, what's wrong with simply replacing the prediction by the actuality? Why, instead of relying upon a prediction as to the outcome, which will probably lead to a settlement in accordance with the prediction, why not simply have a decision in accordance with the AI system? Now, Simon's answer to that, as I've already said, is, well, there's a lacking of accountability. But I think one can go further, because the problem with using AI decision systems to actually decide legal cases is that it omits one of the key elements of the judge's function, which is not simply to apply the law, but to develop the law. And this is true even in statute-based systems like most of intellectual property law. Most of intellectual property law in this country is entirely statute-based. And yet you cannot simply predict the outcome of cases by reading the statute. On the contrary, you have first of all to interpret the statute, and secondly, you have to apply it to the facts of the individual case. And the result of that process is that the law is never static, even when based upon statute. On the contrary, it is always developing. And the problem with the AI approach is that as currently constituted, it doesn't develop the law. Now, of course, the AI developer will tell you that there's a straightforward answer to that, which is a more sophisticated AI system, which will develop the law. And I've no doubt that that will become technically possible. But when you get to the point where the AI system is not merely able to predict the outcome of applying existing law to a particular set of facts, but is also able to develop the law to cater for new sets of facts, then I would suggest the real question we have come to is this: what's the point of human beings?
So I have to defend all of human existence. So no, so you said at the beginning you hadn't read the book. You're going to love chapter 9 because I think we're broadly in agreement that. So let me just respond in three parts. One about legal AI, second about China, and then third about ethics. So on legal AI, you're exactly right. That there's a lot of hype about AI. A lot of AI is basically just statistics. And much as you were saying, when AI makes a prediction, when it makes a recommendation, so all of you have online profiles and you get sort of either advertising or products that are suggested to you, it's based on the fact that, okay, people in your situation also liked this other thing. And it feels like it's forward-looking, but actually it's backward-looking. It's backward-looking on the basis that there are correlations between past behavior that led to something else, and this is an extrapolation. So we use that all the time. We use that in weather forecasting, for example, and it's very useful. And okay, when the atmosphere was like this previously, the next thing would happen, it was sunny or it was rainy, and we can extrapolate for that. But you're right, law is not backward looking, or it shouldn't be. Law must be developing. And so unless you're prepared to hand over that inherently political question of how we develop, imagine we'd done this decision. We said, okay, we're going to hand it over to the AI system, but we did it 100 years ago before all manner of equality provisions were introduced. And we said, okay, we're going to hand it over to the AI systems. That means only white men get certain rights, for example. If we did it today, how do we know what sort of rights we would be talking about? I mean, just the transformation in attitudes towards homosexual or sexual orientation, broadly understood, around the world has been transformed. And that's a healthy thing. It's a political thing. And if we had this backward-looking exercise, it would be misunderstanding the role of law. And I'll come back to ethics as the last thing. But there is a country which has experimented with this, which is China. And as I argue in the book, one of the reasons for that is, well, two reasons. One is technological sophistication, but also a different attitude towards the rule of law. So there is a Supreme People's Court in China. China has a functioning legal system. The Supreme People's Court exists under the Communist Party. And so it's not a rule of law system. And since we're one of the homes of the rule of law, I think it's important to talk about what the rule of law means, which is the law applies to everyone, including those who enforce the law. And so in China, I think there is a much more instrumentalist view, candidly, of the rule of law, where the purpose of law is the development of the socialism with Chinese characteristics economy and the achievement of certain instrumental goals. Underlying this is a kind of larger conversation in the AI world about ethics. There's a lot of talk about AI ethics, and it was only a matter of time, I think, before someone started saying, well, let's get at the ethics as a service. Let's get Google, let's get Oracle, let's get the machine learning system to solve our ethical problems. And this is a kind of a larger version of the problem of misunderstanding law. That implicit in that, I think, is the idea, misconceived as it is, that if only we were smarter, if only we worked harder, we would solve the ethical problems. And so if we had a really smart machine that was smarter than all of us working together, we could solve ethics. But you can't solve ethics. The reason we keep debating over ethics is not because we're dumb. Well, maybe we are, but because these questions are inherently insoluble. They're not meant to be solved. So I was up at Oxford debating utilitarianism with John Tassiolis, and he would actually argue he is right, but I think most, and when he'd had a drink, he would accept that, no, okay, these debates are going to go on forever because they are inherently insoluble. And it's back to this sort of idea, which I think you can encapsulate it quite nicely, which is what's the point of human existence? AI systems are extremely good at optimization. And that's incredibly useful in many areas of life. As I said, sort of transportation, medical care, we want to optimize. But existence, politics, is not something to be optimized. It's something to be lived.
Amen to that. Right, time for a question from the audience. Yes.
Yes, I'm Alex Glassbrook. I'm a barrister. I deal with automated vehicle law. And first of all, thank you very much for the book. It is an absolutely terrific read. I just wanted to ask you about strict liabilities because, in a sense, thank you very much. Another technology which was sort of revolutionary and dangerously, uncontrollably fast was the motor car at the beginning of the 20th century. And in the UK, there was a judicial debate across a number of cases in the early 1900s as to whether driving a car on the road was so dangerous an activity that it should result in strict liability. And in fact, that was resolved in a case in 1909 that answered in the negative and said, no, it should be a matter of negligence. Now, fast forward about 60 years to the early 70s, Lord Denning hints heavily that he thinks actually it's a strict liability because it's backed by insurance. And more recently, the Court of Appeal on a number of occasions have described responsibility for driving as being informed by the fact that the car is a weapon in one sense. It just makes me think of AI, that wonderful, dangerous, uncontrollably fast, but revolutionary technology, and wonder if we're on the same road. Are we about to apply common law principles to something that is not really subject to those principles? Should strict liability be the answer? And if so, to come back to the point so well made earlier on, isn't that in fact knocking at the door of legal personality and strict corporate liabilities?
So fascinating question. So on just on autonomous vehicles, I was one of many people who sort of overestimated how quickly autonomous vehicles would develop. I harbored hopes that my teenage son, who's now 17, would never have to drive. And clearly that's that ship has sailed. But I think you've partly answered your own question, which is insurance will play a key role. And so my own view, and I think it's hard. I think it is important to disaggregate different questions. So rather than just say we're just talking about AI, but in autonomous vehicles, for example, I mean, I think a strict liability regime would make sense with an insurance policy. I grew up in Victoria in Australia, where there's a mandatory insurance regime, essentially no fault, which goes back to the question, okay, what is the problem we're trying to solve? And the challenge, and this goes to the judicial function, the challenge when you're developing things at a common law principles, the judge can engage in a creative activity, but it's not up to him or her to completely sort of step away from the legal regime. In the context of artificial intelligence, if we're primarily intending to minimize harm, to maximize benefits, minimize harm in that kind of utilitarian calculus, then you can legislate, you can transform the legal system in a way that an individual judge can't. So my hope is that we will not do either of two things. We won't leave it completely up to the judges, because there are areas in which it's unreasonable to expect judges to incrementally make decisions on transformative technology. But I also hope that we don't just say, okay, this is AI legislation. This is the problem with the European Union approach, candidly, that it's everything under the sun. It's this sort of grab bag list with an ill-defined sort of concept of what AI is, and there's concerns that it doesn't cover some things, it's over-inclusive in other areas. So you've got to actually determine what is the problem you're trying to solve for, and leaving it to the judges, and the judges will muddle through when the cases come up. So we had a really interesting case in Singapore of mistake. And so how do you deal with mistake? And so the judges came up with, I think, a reasonable conclusion, but that's no way to deal with a transformative technology. And so in the case, again, of autonomous vehicles, there's legislative reforms, there have been royal commissions. I don't think that's going to be the approach in different sectors. And so you've got to pick your sectors. So the wish list I would have would be transportation, medical care, and then the sort of recommendation algorithms and transparency, and appropriate degrees of transparency there. But strict liability would be part of that, definitely.
Right, next question. Yes.
Thank you. Tony Guy's Disputes e-Filing. Thank you very much, Simon, and all panel members for your talk. I haven't, as I ought to confess, yet read the book, but I shall be after today. Thank you. Isn't the way forward in terms of regulating AI to address the issue of the data that is used by AI? Isn't that all we need to focus on? And if we control AI, as you were suggesting, other speakers were suggesting through, for example, those little understood provisions in the GDPR, then the problems go away. But do they not also produce other problems? For example, with AI analysis of health data, which can be enormously beneficial as well. But it doesn't all come down to regulation.
So this goes back to Eleonora's point about access to data. And there's an old line from Silicon Valley that whoever has the most data wins.
Yes.
So data is enormously important, but it's not everything. And this is one reason why China has been so advanced in artificial intelligence, is its somewhat carefree approach to collecting data, although that has really started to be much more restricted as of last year's Personal Information Protection Act. So no, I don't think just focusing on the data is enough. There is the phenomenon of garbage in, garbage out. If you have bad data, then you'll introduce all sorts of problems. But it is the question of what you do. Well, I suppose you can look at it through the life cycle, the collection, use, and disclosure. So the collection, you're right, as you sort of touched on in the medical field. I mean, if my genetic data is uploaded, it's not just my data, it's my immediate family members' data, at least partially as well. And so the desire of companies to aggregate data is understandable because it helps inform their decision making, but what they do with it is then quite different. And there are different ways of manipulating data. This is why we do need more than the GDPR, although the GDPR, as Jacob was highlighting, really forecast some of these challenges because of what was being done with data, automated processing, and so on. But no, I don't think you can just limit yourself to the collection, use, and disclosure of data, because this is one of the problems. And I'm not a machine learning expert. This is one of the problems with the current definition of AI within the Artificial Intelligence Act of the EU, that it arguably doesn't include unsupervised learning. And this is the ability of the AI systems to extrapolate from its own information to develop new insights and to gather more information on its own. So it's not simply that if we control the data sets that we would control all of AI, although it is an important start. Maybe just one last thing on data, and the other panelists might have views on this as well, is that AI, there's a real focus often on AI systems being biased. When AI is never biased, I mean, AI does what you tell it to do. But what AI can be incredibly useful in doing is revealing biases. And this is what we've seen in some of the aggregations of data, the famous cases where Amazon decided that resume screening would be a lot more efficient if it could have an automated resume screening system, because they're hiring tens of thousands of people. And so the AI system was fed 10 years of data, and it concluded, okay, you don't want to hire women. Analyzing that. And so people then think, oh, the AI system's biased. No, the AI system is just telling you what you have fed into it. And so in that sense, analyzing the data can actually be useful, not just in holding the AI system to an appropriate degree of responsibility, but in revealing our own prejudices and biases, which, yeah, so maybe it's a case of the humans needing occasionally to take the plank out of our own eye before we go picking the splinter out of the AI system.
Right, yes.
Thank you, Professor Chesterman, for this talk, and thank you for the panelists for the contributions as well. I'd like to pose a question, and I'd like to frame it in the context of refugee law, but I know it could be applied in different settings as well. In systems like the refugee law, there is an ambiguity, and the discretion is given to people to interpret and determine certain sections in the refugee law. And I'd like to specify, like, for example, deciding a person as a refugee would also lead to determining whether they would have a well-founded fear of persecution. And I'd like to ask whether introducing AI into this decision-making process would standardize or systematize certain processes that were left ambiguous. And would this be, in a way, an alternative solution that would otherwise be solved through introducing external regulations or guidelines, which might potentially create legal fragmentation or complexity? I'd like to ask whether introducing AI into this process would standardize this, and whether would this be a good step into resolving a potential problem, or would this be create additional problem through, for example, introducing a situation the Lord Justice has proposed and AI is developing the law. So I'd like to ask whether this is a good step or additional problem. Thank you.
So fascinating question. So let me break it into two parts. Could we, should we? And I think the could is really the problem at the moment. That implicit in your question is the idea that AI system, and this is some of the most sort of sensitive, this is one of the red lines that the European Union doesn't want, real-time biometric surveillance. And one of the kind of creepy areas of AI is sentiment recognition, where there's some evidence that given enough data points, you can at least draw a correlation with someone's personality, their sexuality, all sorts of things based on this. So could you use AI to determine whether someone has in fact a well-founded fear of persecution? At the moment, I don't think that would be possible, but if you, let's say that you could. So let's say that the AI system is sufficiently robust that it can tell whether people are telling the truth or lying, whether they're really scared. You put them on the equivalent of a very sophisticated polygraph. So let's assume that you could. should you? Well, here again, I go back to the way in which we take decisions like this and the sort of Kantian injunction to treat people as ends rather than as means. And so as much as you do have to engage in decision making, I mean, the judge or the tribunal has to make a decision. It's either one way or the other. I think at least at the moment, most people would have a kind of visceral wariness of relying overly on the AI system. The closest example I've seen in a kind of Western context is the Compass sentencing program in the United States, which many of you will be familiar with. I won't go into detail, but it makes recommendations. You feed in all the data, and it's a proprietary software. So it's not actually opaque, but it was opaque to the judge making a decision. And it almost made its way to the Supreme Court, but it was that human in the loop problem that because the judge said, well, the Compass system says you're likely to reoffend, so we probably should give you a higher sentence. And I kind of think that's right, basically. I don't understand why this Compass system says it, but yeah, I think you probably deserve this. And so the end result of that was that the decision was upheld, but that in future cases, the courts were meant to read in a sort of warning about the limitations of these systems, which goes back to the could we problem. But to me, the really interesting one is the should we, and at least for the moment, I would be very wary. Although, I mean, move away from the legal context to a medical context. And we've seen in the course of the pandemic, all sorts of countries dealing with emergency medicine, where doctors have to make, and nurses have to make life and death decisions very, very quickly. And there, I think sometimes we go in the wrong direction because we're really putting the onus on these men and women to make decisions that are essentially statistical. They're making real-time decisions. Okay, you're likely to live, you're likely to die, and I'm going to help this person or the other. So the thought experiment I'd throw back to you, would you be comfortable with that kind of decision-making? And maybe I'll just do one very quick trolley problem issue, which is that there was a survey published, a study published in Science, which asked the classic trolley problem. Okay, autonomous vehicle, there's 2 people in it, 10 children, and you're in a limit situation, you have to choose, and most people say, yes, save the children, kill the driver and the passenger. Follow-up question, would you ever get in a car programmed this way? Oh, no. And so, yeah, sometimes we're not prepared to live by the principles we might articulate for others.
I can't resist commenting that if you fed the immigration rules into any machine learning system, the response from the machine learning system would be, this doesn't work. Right, at that point, we have to conclude. So please give your thanks to Simon in particular, but also our other panel. Thank you.
Much nicer than on Zoom.
Yeah.